Good afternoon, everyone. It is afternoon. Well, thank you for joining us here for this final panel session of what's been a terrific conference. I'd be remiss if I didn't first thank our host and acknowledge the enormous work that went into this event. These are difficult things. This one's a luxury for us at West Point, where I teach. We call this one an away game, which means all we have to do is think a little bit, find some good friends to talk about an interesting subject, and leave the rest of the real work to Gary and his team. So we're very happy to include this event as one of our very favorite away games at the Lieber Institute. Well, so those who don't know me, I'm Sean Watts. I'm the co-director of the Lieber Institute at West Point. I also happen to be the editor-in-chief of our blog, Articles of War, which Eric Jensen was so very kind to mention yesterday. If you haven't checked us out already and you're interested in the subject of this panel, may I suggest you subscribe? We won't spam you. You'll get one email per week that will summarize our coverage of law of armed conflict issues on our blog. So I hope you'll have a chance to check us out. On this panel, we continue, of course, the theme of convergence. And I was speaking with some of my panelists today and sharing with them the observation that even with 2.5 days of work behind us, it seems there is still some cloudiness, some disagreement even over what an information operation is and what it means for information operations to have converged upon the domain of cyber. But I am at least convinced that it is a thing, never more so than in the opening remarks. I thought Lieutenant General Barrett did a nice job showcasing how information operations have become a part of our lexicon in warfighting and in peace. It's that former dimension of her job that we'll focus on in this panel. So whereas we have treated the subject of convergence and information operations in peacetime, perhaps even in what some might call hybrid warfare scenarios or competition scenarios, during this panel, we're going to discuss exclusively the convergence of information operations with the cyber domain in the context of armed conflict. This will take us, of course, to what is called the jus in bello, the law of war, the law of armed conflict. I'll even throw in IHL there for some of my good friends here today. To help me discuss this subject, I've got 4 experts, and they were all chosen for a reason. I think I will have failed if you don't hear something with which you violently disagree and something with which you vehemently agree. And I will have failed if they don't disagree with themselves. They really are quite a broad sampling of viewpoints in this area. But I want to say that meeting you over the last 2.5 days, I found that you are also a broad sampling of perspectives. So I'm going to steal the approach of my predecessor in so many ways, Eric Jensen. I'm going to open the room during the proceedings. So as we make our comments, as we have our discussion here, please feel free to catch my attention. If I think we can fit your question in to what we're talking about, I'll do my very best. To help that, let me give you a quick outline of what we've agreed to discuss. First, we're going to start with this question of information operations and what it might mean particularly in the context of armed conflict. We'll then turn to a really quick methodological point. I found that so often when I disagree with another lawyer about the content of law, what I'm really disagreeing with them about is how to read the law. There are deeper methodological questions that no doubt inform the substantive provisions or positions, rather, that we take on the law. So I want to open quickly there. They would take my professor card if I didn't talk about methodology or work that into this panel somehow. So we will do that early on as well. After that groundwork has been laid, we'll then turn to the rules that some of you are so very familiar with. We'll talk about attack rules. We'll talk about rules that apply to operations below the threshold of attack. We'll talk about some of the people that are involved in this space. What are the various statuses we might assign to the people we envision participating in information operations? Well, time permitting, we'll turn to some enforcement questions. I think there are interesting dilemmas that we face in enforcing this body of law, particularly in the context of information operations. And then last, we've saved the hardest for last. I want to talk about neutrality. I A couple of the panel members have offered some thoughts there, so we will go to that subject as well. What we will not discuss are two subjects. We will not discuss the ad bellum. I've decided to leave that one to the side for this session. So we will be focusing exclusively on that body of law that regulates the conduct of hostilities. Secondly, we will not discuss conflict classification. I don't want to do a Common Article 2 type analysis. I've given my panelists the leeway of assuming that an armed conflict is in place. Each of the operations they will describe, their thoughts about information operations, and indeed the law that they will describe will be the body of law that has already been activated in the case of an armed conflict. So just a few parameters on our discussion today. So where to begin? Let's start with the question of information operations. Pete, what does that term evoke for you in your daily practice? How do you encounter that term? What's its significance to you as you advise commanders at U.S. Cyber Command?
Well, thanks, and thank you all for having me here. I particularly appreciate the fact that we're focusing on in-armed conflict because it allows me to dress for it, and no tie is always a great day for me.
Yeah, you're dressed for armed conflict.
I'm ready to go. Let's go. I should caveat all my remarks that I'm here in my personal capacity, so please accept that what I say may not reflect DoD policy, which is a good way to ensure that you will violently disagree with something I have to say at some point. In terms of information operations, right? There's the old adage out there that 3 lawyers give you 4 opinions. Well, any term in DoD gets you at least 9 different definitions. And so from my standpoint, we tend to think about information operations in the cognitive warfare, if you will, kind of construct, right? In other words, it's the influence operations, it's deception type activities, it's other things to affect the thought processes of people, juxtaposed from cyber effects operations. In other words, the actual manipulation, denial, destruction, so forth, with degradation with regards to computer or information systems. Now, where this gets complicated is sometimes to deliver that information warfare message, you end up having to do a cyber effects operation. Sometimes it's as simple as a not cyber effects operation. In other words, you're simply using IT systems as designed and intended. Think of it as I'm sending an email kind of a thing, right? My wife deceives me every time I get email thinking that, we're going to do something fun on the weekend, and it turns out we're going to Target, right? And so that's the classic. Up to the much more, I have to conduct an operation to actually get the message through. That's the I've hacked your computer such that when you log in, you see a message from me on your home screen, right? So there's a information operation aspect, there's a cyber operation aspect, and at times you have the two do come together.
And presumably you have a client who's using information operation terms interchangeably with cyber operation terms. A lot of your challenge must be cutting through the non-legal doctrinal terms you encounter and understanding their legal significance then. They can mislead, can they not?
They can. And so I'm those who've worked with me before know I'm a big fan of drop the terms of art and just tell me exactly what it is you're doing. Right. And so when I work with the operators, for me, it's don't give me the doctrinal answer. Sit down and tell me exactly what it is you're doing on a keyboard and to whom kind of a moment.
Yeah, you need to know what the client wants to achieve in the information space. Okay, I'm going to take a big risk here and guess that Jonathan, who joins us from the DC delegation of the International Committee of the Red Cross, information operations and your exposure to it in the armed conflicts context might look a little different than Pete's picture. Although I see he's carrying your propaganda there at the end of the table. That is shameless. That is shameless, Pete. Couldn't someone get you a JAG School documentary supplement? Good Lord. Jonathan, what's evoked by this term information operations where you're operating?
Well, first off, thank you for the invitation.
Of course.
To be at the 3rd annual symposium here. It's always great to be with everyone. So the ICRC, and I like how you talked about sort of stripping away some of the terminology and the confusion that can lend itself to this discussion. And I think the ICRC is starting to do that as well. And so we had originally talked about things like misinformation and disinformation and hate speech. And we're starting to move away from that language and using another term that's going to raise other concerns, but it's harmful narratives, harmful information. But the idea is we're we're looking at the effects, right? The effects in the information environment.
Are these chiefly cognitive effects, or would they include physical effects as well, as Pete alluded to? I'm looking for a little common ground here between you.
So it's gonna be potentially both, and I'll try to explain sort of how we think about that. So first is the information environment provides considerable benefits to civilians living in situations of armed conflict. It may be a vector for learning about where humanitarian assistance can be provided. It provides them access to families that may be broken in terms of linkages. There are all sorts of things that the information environment can do positively with regard to civilian populations or family members of detainees who have been detained by an opposing side. At the same time, that benefit means that when there are vulnerabilities in the form of information operations, it can also disrupt those benefits, right? It can be used to misguide civilians with regard to where they might receive humanitarian assistance, or it might misinform them about safe evacuation routes. And so we start to think about what the effects are in the information environment. And there are three of which we can get into in more detail, but,
Please, yeah.
but three of them are the one I just described, is that you can have the information environment, let's say, corrupted, for purposes of civilians being able to use it for its benefit, for its protection. A second is that there can be escalatory effects. It can polarize communities. It can create divides and divisions. It can stoke violence between armed groups. It can stoke violence between ethnic communities. And to be clear, not all information operations or escalatory information means that it's unlawful, but it does mean that you want to look at potential harms, and then you actually walk backwards to find out where the harm may interact with rules of international humanitarian law. And then the third/fourth category of concern for us is where information operations can actually be violations of IHL in and of themselves. And I can give, one of the easiest examples is that it is prohibited to spread threats of violence to terrorize the civilian population. You can easily do that online, and that would be a violation of international humanitarian law if a party to an armed conflict, for example, were to engage in information operation that intended to do so.
Okay.
So that gives you sort of a layout of how the ICRC, from its perch, both as a humanitarian organization and one that is promoting and disseminating international humanitarian law, so those are our touch points with what we're seeing at the moment on the battlefield.
Okay, about what I would have expected from these respective viewpoints on it. Pete, can I confirm here, the impression I got is that information operations may be challenging to you because it can almost present a Venn diagram of activities. Things which one person is labeling an information operation may be quite narrow, but might at the same time overlap with what someone else is calling a pure cyber operation or an offensive operation or a defensive operation. It may involve kinetic effects as well. Is that the case?
That is correct, right? And so I would argue it's not just even a Venn diagram, let's say within the US government, for example, right? If you think about it, we do most things in this world now with allies and partners. And so you're not just taking, US lexicon in that Venn diagram, you're now taking foreign partner lexicon into that Venn diagram. And so a fair amount of time needs to be spent just figuring out actually what is planned to occur and who is going to do what to whom and for what purpose.
Yeah, re-emphasizing the point of cutting through that jargon, cutting through the doctrine, and being clear about what we're trying to achieve. Okay, thank you for that stage setting there. Okay, I promised a bit of methodology, a bit of international law theory here. Like I said before, very often when I'm unable to come to agreement with another lawyer, the more time I spend with him or her, the more I realize, well, we're just reading this stuff very differently. It's our methodologies, what we think counts as an argument that actually separates us. Mamadou, you've got some, Mamadou joins us, by the way, from Leiden University in Netherlands. Mamadou, you've got some thoughts that might help us frame our legal discussion here and the fit between this pre-existing law and this convergence that our conference is all about. Would you start us there?
Yes, it's really a great pleasure for me to be here for the first time. As a public international lawyer, what I really appreciate here is that we got people coming from different backgrounds. And I believe that to be a good lawyer, you have to really understand the fact on which law is going to apply. And that's really the core element. But now I have to say that I started to focus on these methodological issues because I realized that many people are having different views about almost all the issues concerning IHL in the cyberspace. And I couldn't make up my mind on many of them. I would agree with one today, and then tomorrow I will believe that the person might be wrong and I should rather side on the other way. But the reason why, and therefore I started inquiring as to why. The reason I believe is the fact that no matter how much foresight the drafters of the Convention of the Additional Protocols had, they weren't thinking about cyber when they were writing these provisions. They couldn't. So now we have some texts, we have some articles. They thought that situation will change, that technology would improve, but they weren't thinking as such about cyber. So now we have cyber, which is a reality, and we have norms that were not exactly thought to apply to cyber. We all agree that the general principle of humanitarian law should apply to those rules, and there is a wide consensus. Actually, I think it's the main point of consensus in the community that international humanitarian law applies to cyber. But as soon as you start trying to find out how it does, then you have to see difficulty. And I feel that sometimes we misunderstand the nature of the operation that we are conducting. For me, what we are trying to do is an approximate application of the general principle to a new phenomenon. And as an approximate application, it requires that a little bit of modesty, but even more, it requires us not to be so focused on the exact wording, the exact grammar, the commas of the Geneva Convention and the additional protocols, because this was not what the parties were thinking about. It requires to go a little bit in abstraction in order to see the general principles, the purposes for which the rules were being applied. And I believe that when you take things from that perspective, then you have a clearer view as to where to go. But unfortunately, and I think really that's the problem, we are doing this exercise at a period where many people have characterized it as a lack of trust in the international community, as a lack of trust in the with respect to the main actors. I'll point, for instance, just one main thing. In all the discussions about cyber and international law that I have been to, really, when people were talking, if you decide to go behind the veil, what they were talking about was China, the United States, Russia, but they weren't thinking about Burkina Faso. They weren't thinking about Mali. They weren't thinking about their cyber capacities and how they are able to engage in the law of war with that mindset. So sometimes I feel that rules are being interpreted in taking into account a context which is not as inclusive as society as a whole is. And I think in addition to the current context, we also need to take into account, of course, the nature of cyber, which is evolving, but we also need to take a little bit into account the history. I believe that the humanitarian principles that we have been able to agree upon today are a victory of civilization. They are part of our collective achievement as humankind. And when we reach, for instance, an interpretation that is seeking to say that those principles, those values are not applicable, I suggest that we do it with caution, because it is centuries of knowledge, of practices that have clarified and codified into these rules. And of course, we also have to always remember the Martin Clause. If you reach a place where there is not a full codification of the laws of war, then yeah.
Mamadou, I sense though, a tension between your compelling advocacy of principles and approximate applications, keeping in mind the broad strokes of this body of law that we all study, research, and practice. Isn't there tension between that and the impulses of some of the members of the law of war community? Scholars strive to resolve those ambiguities. Humanitarian organizations publish almost frantically, seeking to resolve these ambiguities. People like Pete, who have to give real answers to real leaders, sometimes need to engage in this practice of interpretation. Are these products, and my own institution produces them as well, are these products serving us well? Are these manuals that tease apart every ambiguity and seek to resolve it and put a finer and finer point on every provision of the law? Are they doing us a service in this area?
I would say here I would generally make a distinction between two categories of rules when I read IHL. IHL does have rules of conduct, and in general, lawyers, we are very good with rules of conduct. You shall not do this, you may do this. And it's quite common, but IHL also has some more specific rules, which are judgment rules, decision rules, in order to guide the decision of the commander on the field. Why? Because the drafters of the conventions themselves realize that these standard exact normative content will depend on the context in which we apply them. So I would say when it comes to rules of conduct, I appreciate the clarity in knowing what you shall do and what you shall not do. But when it comes to decision rules, I would rather say to be very cautious, because the drafters of the convention purposefully chose not to frame them as rules of conduct in order to allow the commander to be informed by the facts on the ground.
And so many of those ambiguities just seem to be reflections of the limit of consensus, right? If we were to be more specific, we would have broken consensus and we might not have the provision in the first place. Lisandra, could I turn to you on this methodological question? Is any of this reminiscent of how you approach these questions from the Atlantic Council? Lisandra joins us from the Atlantic Council.
Thank you. I have to give the same disclaimer as Pete that I'm here in my individual capacity. I think Mamadou has raised some really interesting questions. And I think this principles argument is very compelling. But as you say, when you have to sit down and decide, can we do this or can we do that? A principle is not necessarily going to answer that for you. It can guide how you view what's happening. And I think also in an ex post scenario, it can be quite difficult. And in international criminal law, for example, it's been exceedingly difficult to assess proportionality. Even though we have the principles and even though we have all of this literature, when you have to sit down and judge the actions of someone.
Not a lot of prosecutors charging that, right?
Exactly, because it is it's so difficult, especially because then you can benefit from hindsight and from knowledge that the decision makers didn't have at the moment. And it's difficult to extricate yourself from that ex post knowledge and try to then think about how do these principles that we have, how would they have operated in that moment, given the information that was known at the time? And I think as a lawyer, I love to look at the rules and look at the footnotes and then find the case law. But when I speak to the people who are making those decisions in the moment, it becomes clear how difficult it really is. And I can write you a memo, I can find analysis, but they have to make those decisions in the moment. And I think that also illustrates the lack of consensus. And as Pete was saying, when you involve multiple partners in an operation, they can have these wildly different understandings of not just the rules, but the principles.
Yeah, I'll cue eye roll from Gary Korn because he's heard me say this about 37 times, but there it is. Thank you. I learn everything I need to know about an international lawyer when she encounters ambiguity. What does she do? Does she keep working? Does she keep digging? Does she find one more law review article? Does she find one more 1,200-page ICJ opinion that will clear this all up for her? Or does she say, oh, interesting. They couldn't agree to anything more. This is what I have. These are the parameters. Last word on this goes to you, Pete, but then we'll return to you, Mamadou. I see you there. Legal ambiguity, friend or enemy? I think I know the answer.
It depends. What is my commander trying to do? Right, so I do enjoy the benefit of legal ambiguity from the standpoint of, I think that if you drive to certain levels of precision, you actually are taking options off the table that were never meant to be taken off the table.
Yeah, we call it, it's maneuver space, right?
Maneuver space,
Preserving
exactly.
maneuver space.
That being said, there is value, particularly when working with allies and partners, on trying to drive to that level of precision, because that's what allows us then to do that detailed planning in advance of operations and know that if I'm partnered with you, I'm going, take this out into the kinetic heat because it's easier. I'm going to shoot at the same moment you're going to shoot, kind of a conversation, right?
Yeah.
That's important when you get into the actual operational planning. And so the answer of it depends really is the correct answer in my mind here, because there's value in not taking things off the table and denying maneuver space, but there's value in predictability in planning.
Yeah, and I don't think that's the exclusive realm of those who advise military commanders. I see a similar variety of approaches to ambiguity in humanitarian organizations' products. I think for all of their value, the updated commentaries project by the International Committee of the Red Cross in the 1949 conventions is a rich collection of different interpretive methodologies. There are some common threads that run through it, but I think they showcase a deep variety of schools of thought on how to read the law. I promised you the final word, though, Mamadou, on interpretation before we dig into the real law.
But I really think that in such cases, really, what is ambiguous are the rules, but the principles are a little bit clearer. And they serve as interpretative methodologies in order to know the purpose that the parties wanted to achieve. And therefore, the focus on a principle like the principle of distinction, we all understand where it's coming from. The idea that war is should not be an end in itself, and it has to abide by certain rules, that humanity has to be preserved, can serve as North Pole, North Star, to guide the interpretative process. It's my belief. It's perhaps an act of faith, but I believe that it gives a little bit of clarity when we are reaching these situations where rules were not exactly conceived for certain scenarios.
I like the navigational reference there, a North Star or a North Pole. Okay. Oh, look at it's lit up. Let's start with Gary, please.
I agree with you sort of in part. And I think there's a reason why the DoD Law of War Manual, for example, starts out talking about the principles. Right, these are the framing concepts that should help us think through these issues. But at the same time, there's a bit of a kick the can down the road aspect, I think, to what you're saying. Because part of it is, what principles do you give greater value to? How do you predominate those? How do you feed those into your analysis, as opposed to the hard work of legal interpretation? And to Sean's point, sometimes there's simply not an answer that's easily identifiable, which means that maybe there's maneuver space, and that you may want to give prudential advice to your commander that's based on a principles-based approach. But for example, this I think comes up a lot I heard it yesterday, when we talk about object and purpose, right? Object and purpose is another way, I think, of saying principles. But the way the object and purpose of LOAC treaties is often portrayed is humanitarian protection. I'm not against humanitarian protection. Let me be very violently clear about that. But military necessity is a principle. Military necessity is part of the object and purpose of the treaties, and to preserve the ability to actually fight and defend oneself in the unfortunate circumstance where you're dragged into conflict. So how do you reconcile that in thinking through that principles process, as opposed to sort of kicking the can down the road with that?
Let's take that one just for reflection later. Eric, your point?
So I was at a Lieber Institute sponsored conference at West Point
Imagine that.
a little while ago where they.
I bet it was
talked about-
awesome.
It was amazing. Where they talked about, one of the presenters talked about the principle of proportionality versus the rule of proportionality.
Yeah.
And so Mamadou, I would just like to, this division between rules of conduct and rules of judgment.
Yes,
Where would you put proportionality? Is it a
Judgment.
rule of conduct or judgment?
judgment.
And why so?
Judgment, because it really requires you to look at the fact of the case in order to be able to determine whether the damage that the civilian damage will be excessive compared to the military advantage that is being achieved. And that's not something you can put into a general rule, abstract rule, where the commander will be able to, you really need some cognitive process of engaging with facts and balancing them out in order to come to a conclusion.
Eric, you've given us a nice segue, though, to some of the more specific rules, which I think we'd like to turn our attention to now. So I'm going to go back to you again, Pete, for starters here. So you've satisfied yourself, you're in an armed conflict, you know the body of law, we know as law of war, or IHL has been activated. You've satisfied yourself, you've got something that smells like an information operation. It's certainly in the cyber context because it's got your attention, it falls within your mandate. What's the next legal step? What do you want the lawyers that work for you to do next?
So may not be the exact legal step, but to stay where the panel is focused, right? Question is it an attack under the use?
Why? What's the significance? Is
Because
it
now
an
I start
attack?
talking targeting principles of distinction, proportionality, precaution in the attack, and so forth, right? And so for me, that's that threshold, right? Are we talking an act of violence, an offense or defense against the adversary? And now, right now, this kind of goes to Mahmoud's point about, you know, what do we mean by active violence a little bit here, right? And so you can get down into the weeds of, you know, in the kinetic world, that's pretty obvious. Things tend to explode, people tend to die. That's wonderfully stark and in contrast. In the cyber and information operations construct, right, this gets a little bit more complicated, right?
Yeah.
It is pretty rare that a cyber operation is going to cause things to explode or people to die. Technically, in certain circumstances, feasible, possible. But if history thus far has shown us that the majority of cyber operations don't lead to those same kinds of kinetic direct consequences. Certainly adverse impacts to an adversary, but not necessarily in the same kind of kinetic world.
Okay. The US is well known not to be a party to Additional Protocol 1. So as a technical matter of law, we are not bound by the Article 49 definition of attack. But are you satisfied that it's reflective of custom? Is that the standard or similar enough to the standard that you use?
Yes, it
Okay.
is, right? And so for me, right, really what we're talking about is that act of violence.
Violence.
So really.
Against an adversary as well, right?
This comes down, yes.
Okay.
Yes.
So now to you, Jonathan. The ICRC has produced numerous products on this question, some provoked by precisely this convergence we're talking about, the possibility that some information operations can potentially meet this attack threshold. But let's slow it down a bit. Walk us through how you might analyze an information operation and conclude that, yes, it is an attack and therefore has the legal consequence of activating the obligations that attach to attack operations that Pete mentioned before, the precautions obligations, the distinction obligation, the proportionality obligation. What do you say, Jonathan?
So, on the question of attack, I'll get to that in a moment, but I do want to put an emphasis on additional legal questions that should be asked that are irrelevant with
Fair
regards
enough.
to attack, but are very relevant to the rules of international humanitarian law. I already mentioned some of them, but I just want to sort of foot stomp that because I don't want there to be a misunderstanding that the ICRC thinks about information operations as engaging IHL because it is or is not an attack. So I already mentioned one, the threats of acts of violence for purpose of terrorizing the population, the display of images of prisoners of war on social media outlets that would engage with the prohibition against insult and public curiosity, the issuance of flagrantly unlawful orders to subordinates through social media platforms. I realize this is a little bit outside of information operations probably, but in
Sure.
terms of the information environment that the ICRC is concerned about,
Yeah.
certainly you could, try to recruit child soldiers through information campaigns that would be in violation of international humanitarian law.
Yep.
The list can kind of go on. There are a few other things worth mentioning.
Right.
Information operations, and this probably could be considered information operations that encourage civilians to violate international humanitarian law,
Sure.
would engage rules of prohibited conduct. And so I just want to open up that space for us to think a little
Certainly.
more actively. Now, when it comes to an attack, the ICRC is a advocate of understanding definitions of attack through the effects thereof. Also the means, but also the effects. So something that the International Committee of the Red Cross would do is that if there's an information operation that can be expected to cause the effects of death, injury, or damage through, and I'll get to this point because Peter's an important one, I think, through violence,
Mhm.
the ICRC would start thinking about that information operation, how it engages with the definition of attack, if it meets that definition, and therefore whether or not rules of distinction, proportionality, precautions would apply. So the thinking that we've put into it at the moment, and there are a few states that have sort of indicated that they're in agreement with this, a few scholars that have done the same, if you have an information operation that has a direct causal link, I'm not using the language of DPH, it's not what I'm doing here, but has a I know you're gonna come at me with that. If there's a causal link in an information operation that can be expected to cause death, injury, or damage, that should be there are indications that could be treated as an attack. So the example would be an information operation that leads a civilian population down an evacuation route that is actually a minefield,
Okay.
right?
Yeah.
So it has the effects of causing death, injury to civilians or to human beings. The principle of distinction would apply.
What about this term against the adversary, though? Does your example count as directed against the adversary? My understanding from the Travaux of 49 is that the term against the adversary, violence against the adversary, was imperative language.
So my
It was
understanding.
proposed to remove it, but the drafters rejected that. States rejected that.
So my understanding is that that would essentially hollow out the protective qualities of the principle of distinction if a party to an armed conflict could direct an attack against a civilian village and then claim no violation of the principle of distinction because it wasn't directed against an adversary. So our understanding has consistently been that an act of violence in offense or defense at the adversary would include the civilian population in the territory, for example, of a party to an armed conflict.
Is the concern that not failing to call those directions to move through a minefield would put us in a legal void, that there's no law remaining by evading attack?
No, I think it simply, there is a law, it does apply, and
But it's the
speaks
law of
to
attack, the precautions.
the rules of conduct of hostilities would
Okay.
apply. Now, just to add one more sort of more than a footnote to this, we've also looked at the idea of what happens if an information operation tries to direct a third party to commit an act of violence. There we see
Against whom?
against, let's say, the adversary, the party to an armed conflict.
Okay.
There we see states, others being much more cautious about, because of the causal link,
I see.
about regarding that information operation through a third party to cause death, injury, or damage,
Yeah,
that we're more cautious about thinking that states would have the appetite to apply conduct of hostility rules to that type of information operation.
let's
If that
turn
makes
now,
sense.
let's turn to Lisandra now. Reactions to this approach to interpreting attack. And then Mamadou, I want to come to you to perhaps bring in the interpretive considerations, methodological considerations that we're showcasing here. Lisandra?
Yes, I mean, I think this is one of course, the essential questions when it comes to cyber, especially regarding the dual use nature of how much is encompassed by cyberspace, and whether then, of course, with the principle of distinction, is this primarily a civilian object, for example, and what is its use? How long is it being used? What military advantage is it conferring? And I think that these questions have also been demonstrated, for example, in international criminal law review of attack and what exactly that definition is, and whether that encompassed the civilian population or whether it was directed at specifically the adversary. And I know that there is disagreement between law of war scholars and international criminal scholars on the scope of attack. And I think that that is going to also start becoming an issue here in the cyber realm as well, because of how much it touches upon civilian life and the consequences of possibly having this legal void of protective elements in the instructions that commanders and those directing attacks and information operations should take into consideration when assessing their targets and also the means and methods.
On this attack question, you're talking about the Taganda case at the ICC, right? Yeah, where the court is urged to adopt a distinct meaning of the term attack for international criminal law purposes, perhaps a broader one than is understood in the law of war community. Well put. If you want to know more about this, it just happens we ran a series on articles of war on that very question, and we've revisited it as well. You can find there the entire range of views on this meaning of attack. But considering there is a range of views, Mamadou, this tees up our methodological question again. What's the appropriate methodology for resolving the conflicting potential meanings of attack?
I think that's really, but I think that it's a difficulty. It's really a difficulty. And that's where I would start not trying to go to the nitty-gritty of what words mean in concrete and think about the humanitarian purposes. Yes, I understand.
The positive for me is teaching.
In the room, don't worry about the nitty gritty.
No, I'm not saying not to worry about the
Yeah.
nitty-gritty of the language, but it is also to understand that really does not convey everything. And that sometimes in order to make sense of the words that we are uttering, we need to look at the context, the purpose, and that their finality is really what makes the most of the meaning.
And
So
that
that is-
absolutely guided a segment of the court in the Taganda decision, didn't they? You read the decision, the elements on attack, and you can see frustration with this obsession over was the term against the adversary essential to agreement on this. Many of the judges are border unimpressed by that argument and want to step back in the way that you suggest. Pete, I want to give you the last word perhaps on the attack question. I bet you've been taking notes.
Yeah, I actually want to go back to something that Lisandra raised, right, which was the temporal element you talked about there for an object. And that causes me grave concern when we start talking cyber operations, right? Nothing moves as fast as an electron in modern warfare. And so when we start trying to infuse time element into the analysis, I worry because I think that is fraught with danger from a standpoint of both, well, someone's going to want to decide what's the de minimis, or minimal time you have to use something for to qualify. And then more importantly, that creates a particular challenge from an intelligence refresh rate for commanders to make reasonable decisions. right? And so I just, from my standpoint, that's a danger area to step into when we start talking time as part of the object analysis.
Is it always the case then, Pete, that you'll have the information you need to sort out the attack, not attack question?
So you always want more information, at least the lawyer always wants more.
Yeah, and you want more time.
Right, I know that, right? Time and information, the two things I never have enough of. The challenge in my mind though, right, is because trying to sit there and say, well, this particular router was used for, the last 3 days and therefore it's good enough versus it was only used for a day versus what's going to be used in the future, right? And so once I start talking time, that to me becomes a real challenge for determining, does that object qualify as a valid military objective, right? Because, how long does it take to set up Wi-Fi in your house, right? About 30 minutes if you're, following the instructions, 15 minutes if you ignore the instructions.
Couple of years.
Or 15 minutes if you leave the default password, which please don't do.
Like you ask your kids to do it.
And so my point simply is, right, the environment can change so quickly that trying to infuse a time element, amount of use to me is a concern, right? And it also creates that, what do you do from that best available information for a commander?
I'd like to take us now to a question, Mamadou, that you raised, this question of uncertainty. The cyber realm, cyber warfare, information operations are plagued by uncertainty. Some of it is owing to the nature of this domain, but a lot of it is deliberately infused into that domain by the actors who operate in and through cyberspace. Help us with some of what the law of war offers us about certainty in decision-making. Pete has explained quite well that very often he works in an uncertain world owing to time and lack of information. What is the law of war telling us about certainty?
Yes, I think that on that point, for instance, we have some clear rules, which is that if in case of doubt, a person has to be considered as a civilian. And in case of doubt, an object has to be considered as not making a contribution to the military advantage. So I think that these are presumptions. They are presumptions, and they also again raise the same question. When is doubt? Is doubt subjective or is it objective? And those are issues where we will need again to be able, it's easier to do an ex post facto review than to make an ex ante determination of when is a doubt and trying to shackle commanders. And you see that here I'm taking the military necessity seriously, then trying to shackle commanders with a list of, okay, when this happened, you have a doubt, and when this happened, you don't have a doubt. But my main point is that the rules give us and the principles. When the rules are not meant clearly to address a situation, it's better to take the step back and look at the principle, both principles, but not more in favor of the other.
So you cited the obligation to presume that objects are not military objectives in a case of doubt, and the obligation to consider persons with respect to whom you have doubt as civilians as well. Those each appear in additional protocol 1 beneath the attack threshold. They're in a section of that tree that pertains to attacks. Are those presumption and is that consideration with respect to persons something that extends beyond the attack question? Are those rules that apply to non-attack operations?
I think particularly with respect to non-attack operations, what I would think about is rather Article 57 of the additional protocol and the duty of constant care in all military operations.
I want to come to constant care later. But I see that you're considering those as perhaps part of the constant care duty. Now there's a separate way to phrase this question, of course. Do I even care if someone's a civilian or a combatant if what I'm doing is not an attack? Is there room for the operation of a rule or principle of distinction when the thing I'm doing is not an attack? It's not violence against an adversary? Pete?
Yes. The easy answer, right? So is there more room and maneuver space there? Absolutely. It's not an attack, right? And so while I don't dispute Jonathan's great articulation of there may be other IHL rules that, preclude the conduct you're contemplating. But in this case, if it's not an attack, there's a lot more maneuver space in terms of what can be done, right? And by the way, I'm not saying that's good. I'm simply saying, right, remember IHL sets a floor, kind of the minimum conduct necessary.
Let's put some meat on those bones. What are some of the non-attack things that you understand we can direct right at civilians, not incidental effects, but things we can do directly to civilians?
So there's in my view, at least, right, emphasis Pete's view, not necessarily DOD.
Of course,
view,
disclaimer.
right? While you can't terrorize civilians and you generally want to protect civilians from the harms of war, despite what my 13-year-old daughter will tell you, loss of internet is not a harm of war and something that's protected by international law, right?
Okay, yeah, so
those kind
jamming.
of inconvenient, exactly right. It's no difference than the cyber jamming version, if you will.
Okay.
Right, throttling of bandwidth,
Okay.
those kinds of things. Depending on specific facts and circumstances, may be the kinds of things that can be done, assuming you've got a valid military purpose for why you're doing this. And in my world, if there's not a valid military purpose, you're not going to do it simply because you don't have the time and resources to spend your time doing those kinds of things that are not going to achieve a military.
You're suggesting a necessity element, overarching necessity element to it.
Yes.
Okay, Jonathan, it's time to hear from the ICRC on this. The attack question has been, I think, teased out a little more detail since we last heard from you.
So I got worried where Pete started, and I appreciate where you ended. Right? So I think the running assumption has been information operations, psychological operations, espionage, things like that are fair game under international humanitarian law. I think as we start to see practices
Fair game, build that out for us.
Unregulated by international humanitarian law.
Ooh,
as a running assumption. And I think that is something.
not an ICRC view.
Absolutely not. And I think as we've seen practices and as we've started to dig a little bit deeper and try to uncover what that assumption could mean, we quickly find big exceptions, right? So a information operation that would interfere with or disrupt the medical mission or humanitarian activities, which is prohibited because there's the obligation to respect and protect those two entities that is maybe short of an attack would be a prohibited information operation. And so that type of, I would say, contextualized understanding of what the effects would be is absolutely critical. And one of the difficulties is that means you need to know the information environment in which you're operating, because those interruptions of medical services or humanitarian operations may be tangential, maybe incidental, maybe indirect to the information operations main, quote unquote, sort of target, to use a different language from the law of armed conflict. And so from international humanitarian law. And so I think that type of nuance is what's really required, as in particular, as both parties to armed conflict, including non-state armed groups, are increasingly relying on the information environment to carry out and to pursue their military goals, purposes,
to achieve effects,
to achieve effects in their ultimate military means.
Yeah. Okay. Before we move on to the non-attack question, so those of you keeping track of the outline provided, we have worked our way through attack. Now we're going to address non-attack, but before we do, I got the signal of a question from the audience, please.
Yes. So when you're talking about cutting off the internet, I think me and Mr. Johnson kind of have the same point of, we're looking at surface level. The attack, it may not be deemed as an attack, cutting off internet, but what if that results in the cutoff of resources? Do we look at the bigger picture, or are we only looking at the one act that we're doing to civilians?
So if I understand the question correctly, I think really what you're asking about is kind of reverberating or cascading consequences from an action. And I think to the extent it's reasonably foreseeable, then yes, you consider that in, right? The cyber effect that manipulates the SCADA control system of a dam such that it opens the floodgates, right? I don't stop looking there. I include the what's downstream in that, right? Because the reasonably foreseeable consequences of that is whatever's downstream is probably now under, water, kind of a construct. So I think you do in that regard. I also think that when you do that, you need to be careful how far you take that, right? At what point does, the fifth order effect, does that really get factored in? Because to what degree do you have sufficient information to make that kind of an assessment and judgment? So there's a degree of reasonableness, I think, that has to be infused as you start looking at that.
Thank you so much.
Thanks for the question, and thank you, Pete. Asaf.
I'm just astonished by the fact that throughout this entire conversation, there was no reference to concurrent application of human rights law, even in the slightest. And yet so many of the ambiguity that you're.
That's my fault, Asaf. Yeah, we setting some parameters for the discussion,
but
Justin Bello.
I believe that, but obviously in the process of discussing the ambiguities you all are discussing, it cannot be the case that some of these are not influenced, at least in the periphery, by a consideration, in part because the technologies themselves will embed human rights because the companies are saying that they are bound by international human rights, or at least some of those big tech companies. In part because the way the frameworks will be assessed, especially in the domains of data protection, cybersecurity, internet shutdowns, is in part influenced by an understanding of what are the baseline rules of cybersecurity and data protection, which are echoing those language. And so I just don't know how we can have some of these broader conversations without any.
There is an interesting, methodological question you're implicating there. Most of us are familiar with the lex specialis rule. Now, some of us use it to great effect to exclude entire bodies of law. Some use it perhaps at a more granular level to compare the availability of rules. So we might do it at the regime level, we might do it at the rule level. I do notice in products like the ICRC commentaries, what I sense is a reversal of the lex specialis rule, a temptation to take an ambiguous rule of the laws of war, but use human rights law to inform its meaning. To me, that reverses the flow, however. That's taking a body of lex generalis, a body of law that applies generally during peacetime and to all persons, and in some views, all places, and using that generalis to inform the specialis. So it's certainly out there. I think it's got quite a lot of momentum in academic communities and even humanitarian communities as well. Okay, last point on attack goes to Jim. Then I want to talk about non-attack, just in the interest of time.
Real quick, I thought from Mamadou, I thought his point about the principles being sort of we can't, if the rules by the words sort of become difficult to apply, we look to the principles. But I think isn't what we're really struggling with is the agreement over the harms we're trying to prevent. Because, to this point, this is an armed conflict. In that armed conflict, we know that in the 49 conventions, 77 conventions, they're thinking about physical damage to human beings. They're thinking, obviously, about protection of the medical function. They are talking about terrorizing the population. But I think where we were struggling with is what exactly are the harms we're trying to prevent, and get an agreement on that, then that can then orient us towards these ideas. I just wonder if that's possibly a useful way to look at it, as opposed to, we have this notion, if we apply these rules, we arrive at the place we want to be in terms of humanitarian protection, but we get into a new domain and these rules weren't designed around the domain. So maybe we could try to reach agreement on what the harms are. When you talk about human rights law, different set of harms. IHL, basic IHL, which is preventing civilians from being injured, civilian objects being damaged, medical function being protected.
Yeah.
That sort of thing. So we need to have some agreement about how we look at it. Because I think as an operator, I would be looking at what am I trying to protect, and then go beyond that. Then I'm looking at, is there any kind of a positive law that says I just can't do something, but I want to make sure I don't do the harms that they're trying to do.
Yeah, Mamadou, that is reminiscent of your opening remarks. But Lisandra, can I give the question to you?
Yes, absolutely. I think this goes back a lot to uncertainty.
Yeah.
And if we can see state positions, for example, if I may quickly go to the jus ad bellum just for a second, we can
that's
see
a low blow.
This definitional battle on, for example, when a cyber attack would constitute a use of force, such that jus ad bellum is then triggered. And I think you see states arguing about what exactly these harms are that we're trying to avoid, what exactly the scope of this is, right? Is loss of functionality of a system, of a nation's entire banking system, is this what we are going to view as an attack in the sort of larger context, and what informs those decisions? And I think it is precisely the harms that we're trying to avoid, and also this uncertainty in this new space of, I would say, the expanded ability to inflict harm through the tools now available, also to more than just the traditional powers, as Mamadou mentioned. We're not just talking about a few countries here. As technology expands and becomes more broadly available, so does the ability to inflict harm on a
Undoubtedly.
wider scale.
Yeah, the potential to inflict harm, the vulnerabilities this domain introduces, the way it might super empower information operations is beyond debate, I suspect. Okay, non-attack operations, we've danced around it a bit, but I want to take a chance to fill out the rule set that applies below the attack threshold. So if you're the flowchart type and you're envisioning, yes, I have satisfied myself, there is an international armed conflict, I've activated the body of law that is the law of war. You took the next question as Pete proposed. Well, is the operation either I'm considering undertaking or that the adversary has taken against me an attack? If the answer is yes, we have a quite elaborate rule set that applies to attack operations, both in custom and in additional protocol 1. But if the answer to that is no, instead, I get to no on the attack question, what does the rule set look like there? By comparison to attack, you could conclude it's less developed. Mamadou, I promised you the first word on this notion of constant care. Thoughts on constant care and non-attack operations?
Yes, again, as you can see from even the wording of the obligation to provide to exercise constant care, it is a term which will have only meaning with respect to special circumstances. It will have meaning with respect to special circumstances, but what you can already grasp from the literal meaning of it is that it prohibits recklessness. It prohibits recklessness.
Acting without regard to consequences.
Yeah, acting without regard to consequences. It prohibits recklessness. It also prohibits the fact that you show care just partially.
I'm sorry, say that again?
Showing care just for a moment, for a period of time.
That's the constant element.
That's the constant element.
Okay.
So you see, I believe that you can tease out a number of general principle again,
Okay.
that will need to guide now the commanders as they are shaping their military operation. But I have to say that what I saw, and this is probably where I started thinking about this methodology, it was all the interpretative techniques that were used in order to equate military operation only to attacks. And there I felt that it was going a little bit far by focusing on terminology and saying, okay, of course we have Articles 57, paragraph 1, but when you look at the rest of the paragraphs, they focus only on attack, and therefore...
And the Article 57.1 articulation refers not to attacks, but rather to military operations. Yes, okay. So you are, there's a textualist in there somewhere, Mamadou, right?
There is one, but I believe that when text reach its end, we shouldn't conclude that there is a gap.
Fair enough. Jonathan, constant care.
So
Put some meat on the bones for us.
So I think before we get to constant care, we have to find out if information operations are military operations.
Okay.
Because constant care
Let's do
applies
that.
to military operations. So one is I would commend everyone to my colleague Tilman Rodenhauser's piece in International Law Studies, where he walks through a lot of what it is that I'm describing. Those are his personal views, but they reflect some of the maturing thinking and conversations that are happening within the legal community of the ICRC.
Okay.
I think it can be it's an open question, depending on the type.
What
of
is or is not a
information,
military operation
whether an
for
information
purposes of
operation
constant care?
is a military operation, because
Okay.
if it is, it's subject both to the ICRC regards as the customary rule of constant care. It also would apply to the AP1 rule that an information operation cannot be directed, if it's a military operation, against the civilian population. So there are actually two things that hinge on whether or not an information operation constitutes a military operation.
How beholden is that determination to the labels that sovereigns place on their organs? If it is a non-military organ of the state that is conducting the information operation, are you suggesting that the military operation aspect of constant care is not satisfied?
No, what I'm saying is that the quality of the information operation, something that if you look to the commentaries, there's mention of propaganda, espionage that would not constitute a military operation.
Oh, really?
Yes. On the other hand, there are information operations that may not produce the effects of violence that could be harmful and detrimental to the civilian population.
Mhm.
Does IHL provide an answer to that, what would otherwise be a protection gap? See constant care and the importance of applying constant care to an information operation that could have a detrimental effect on the civilian population. So this is I think it's also very important to say the ICRC is regarding this as an emerging interpretive issue
Yeah.
that states still need to provide additional clarity on.
It is a relatively recent vintage that we're all trying to understand what constant care really means.
And how information operations are used by parties to an armed conflict for them to influence the outcomes of their military goals. And so
Fair enough,
you
yeah.
put those two things together and you get, I would say, my recommendation to read Tillman's piece, because he starts to walk through what the questions are, where states have spoken about these things, probably more importantly, where states have not spoken about these things. But from the ICRC's perspective, to your point, what harms can come from information operations? And if there are harms, you're going to start thinking, what can international humanitarian law, what can international human rights law do to potentially respond to
Using
those
human
harms?
rights law to fill out our understanding of the law of war term, constant care.
I did not say that.
That was a trap. You got it.
Because I think there are different methodological approaches to filling gaps in understandings and interpretations. One is you can use updated contemporary evaluations of how human rights are protected that are completely unexplored in the textual rules of the Geneva Conventions or the additional protocols.
Yeah.
On the other hand, there are places like the presentation of images of POWs into the public sphere that add considerable detail into a rule of international human rights law, freedom of expression, right to privacy, where international humanitarian law, it does do that less specialist work that people are comfortable with. So continues to be a rule by rule evaluation for the ICRC on understanding what the relationship
in the information operation context. And for those interested in more on this question, you should check the scholarship of Asaf. He's done a lot of work on potential approaches to filling out the meaning of constant care. I think even last year, your presentation here showcased some of that. So please, everyone, check that out. Asaf, you should write for Articles of War or something. That would be pretty cool.
I can also say Kubo has a wonderful piece on this question of how the ICRC in its commentaries is approaching and thinking about the relationship between IHL and IHL.
They do that richly.
That's a much
deeper
portrayal of the issue.
Well, Pete, so Jonathan mentioned earlier, there are states that aren't saying much about constant care. That made me think of the United States. How, if at all, does constant care figure in your practice?
Well, considering it's mentioned, I think total of twice in the entire DoD Law of War Manual, not in the same section.
1,500 or so pages.
Yeah, if you do it, we're fine. Which I may or may not have done in preparation for this. I think we would come at it a little bit differently, right? So, right, US not a party to AP1, US doesn't believe it's CIL. That being said, I think I put a lot of stock in my practice into what Jonathan pointed out about, military operations and the general protection of civilians from the harms of military operations. And so, for me and just things that come across my desk, that's the lens through which I think I'm going to look at this particular problem set. Also, there's a practical aspect to this, right? And if you need validation, I'll look at 20 years of counterterrorism operations. bad things to civilians don't end well for your government, right? Even if there's civilians on the other side, right? And so harming civilians is not going to help your military objectives. I'm talking strategic level objectives at this point. And so very practically, I'll be honest, I don't anticipate much of this coming across my desk because it's not going to achieve a nation state's strategic objectives. And so a military force is presumably less likely to seek to undertake things that are not going to achieve objectives for them.
But are these obligations you present to your commander as legal in nature, or are these merely considerations you're recommending? Are you wearing your lawyer hat when you're counseling this way?
So I'll start with the lawyer hat, which goes to the military operations and protecting civilians from the harms of war kind of construct.
Okay.
There's also now, for those that may not be following, there is a DoD policy hat, which is not my responsibility, which is a separate office, which is the Civilian Harm Mitigation and Response person action. Yes, just forget what there's the action plan, and then there's 3 people, then that's their job at our command, right? Is to look at how you minimize harms to civilians, right? And so that is the above and beyond that which is legally required. That's the, there's the legal floor, which I'm surely responsible for, and then there's the policy floor, which is elevated higher. That is what they're responsible for when you're talking things that amount to an attack, principally. I will tell you, again, Pete's personal view, that latter section scares me. Right? Why? Because that is going to at times get conflated for law of armed conflict IHL adherence versus policy adherence, because they use similar language, they use similar processes. And so I am concerned that over time, that's actually going to confuse the matter and either for countries, at least in this case, the US, inappropriately elevate the floor, or worse, create confusion as to where the actual legal line is, such that we may end up where situations where someone thinks they're taking a policy risk, but they're actually taking a legal risk. And so I am not a fan of that, despite the fact that SecDef signed it. So yes, aye, sir, we're executing.
Presumably that is the job of lawyers then, isn't it? To keep that clear, to prevent that bleeding or bleed over?
Yes, devil's in the details for how it gets applied.
Yeah, perhaps easier said than done. Yuval, please.
Yeah, but Pete, on the jamming example that you gave before,
Yeah.
I mean, that would be a case where you would have to introduce through constant care, some proportionality analysis. Would you disagree? If you do not treat it as an attack. And this would be your only normative vehicle to do the kind of calculation you implied that you would be doing.
Well,
in terms of the reverberating effects or whatever.
So I would argue, first, if it's not an attack, I'm not talking enveloped proportionality rules, right? Second, US not a party to AP1, not reflecting constant care as customary international law, right? And so really, instead, I'm looking at a much more.
There's twice in the minute.
Yeah, I actually have the section if you want it. One section that says some parties
So
will follow.
it does mean something.
It means something vis-a-vis working with allies and partners, which is, I think, the larger conversation, right? Which is, to the extent, I'm working with you all, for example, right? How does that, my actions implicate you? How do your actions implicate me, right? So that's to me really where the conversation meets the road. But I go back to the whole, what's the nature of the underlying operation being conducted? What's the purpose you're seeking to achieve? And so I also
treat it as a policy.
Pete, you were careful to distinguish the in bello proportionality rule, which requires either injury to a civilian person or destruction of an object, death qualifying as well to a civilian. But of course, if we're below the attack threshold, we probably aren't dealing with those kinds of effects. So is there a different rule of proportionality? Is there a sub-attack version of proportionality?
No, that's not what I'm advocating for. My
Okay.
point was simply that because it's not an attack, I'm not doing the proportionality.
Off the table. Okay, fair enough. Emily.
So the really only change the DoD Law of War Manual with that civilian presumption.
A little louder, Emily.
Oh, I'm sorry. The only change to the DoD Law of War Manual this past year, sir, was that presumption, which is more reflective of AP1, although not exactly the same. So does that change, and I know it's policy, but does that change bring us any closer to constant care-esque kind of considerations because of that flip, or did that really have no No
Good question.
effect
Yeah,
at
did your
all.
life
Yeah.
change after those changes?
My life did not change, thankfully. I was not on the inside of that conversation, so I don't know the background behind it, if it was the alignment. What I think it did in my mind is, I don't think it really changes the standard by which commanders are looking at it. I think what it did was put it in a vernacular they're already used to seeing with in other situations and other circumstances, right? So to the extent that you can meet the same legal obligation and threshold using language that commanders, may otherwise be familiar with, it's helpful to them because then they have an anchoring point, right? So to the extent you're in an interpretive situation, what their methodology is, they're already used to having to make those kinds of decisions. And so while the lawyer always wants to see the exact verbatim language, let's be honest, none of us tend to write in a manner that truly speaks to commanders. And so, right, we like 12-page memos, they like 2 bullet points. And so how do I give them the 2 bullet points in a manner that ensures they factor the right things in, they conduct the correct analysis, such that with the best available information, they make the right determination, hopefully, but in a manner for which they are already used to thinking about a particular problem set.
Ori, to you quickly, but then Lisandra, I'd like to turn to you after to talk to us about people, how people figure into these operations. Ori, please.
I guess going to the methodological question, I mean, we've, on the one hand, been focusing a lot on text. On the other hand, as Sean mentioned, as Peter alluded to, there are certain states which aren't parties to the AP1. Certainly AP1 is not applicable in non-international armed conflict. And then we get to customary international law. And I'm wondering what your takes would be as to, well, how do we address these so-called gaps, or do we not address these so-called gaps in customary international law? Is there a way around the requirements of state practice and opinio juris? Or is actually customary international law at least something fundamentally different than what's being advocated as perhaps by the more expansive interpretations of the additional protocol?
Mamadou, could I give that question to you, but then I want to go to Lisandra on the people question.
I think it's a genuine question, and it's a question that goes onto the condition of the creation of custom. Of course, you can have the formalist view where you need practice and opinio juris, but we all realize also that there are certain normative discourses that you just cannot put in public, just because you understand that the audience to which they are directed will not receive them well. So there are some social pressures which do not necessarily equate to opinio juris, but which also form part of the shaping of conduct. So now, if you are the ICTY in Kupreskic, you will use this normative social pressure to say that a customary international law norm is wrong. And if you are the US writing their comments to the ICRC manual, you will take another view on the same issue. Yeah.
Thank you, Mamadou. Lisandra, I apologize. In addition to opening up a new set of harms, perhaps, information operations also bring in a new cast of characters, it seems, to armed conflict. Tell us about what you're observing there.
Yes, absolutely. And I'm glad you made that point, because it's an equal two-faced phenomenon, not just the increasing harm, but now the number of actors. It no longer is the state the sole arbiter of violence in these conflicts and who is typically involved. Now you have, of course, civilians who are maybe even recruited by the government. I'm thinking here, Ukraine's IT army, to become involved in war supporting operations, but that are not integrated as a formal organ of Ukraine's armed forces. And where do these people fall into the analysis of their legal responsibility?
Yeah.
You also have civilians who of their own volition want to become involved. And these can be good faith hackers who want to support a particular party, but you also have organized crime that can see an opportunity in the chaos to participate for either an aim to support a particular party or simply to profit.
Having a nexus to the conflict.
Yes, they still have the nexus regardless of their individual motivations.
Yeah.
And of course, you have the private sector whose technology is being used by these people and in this manner. without their consent necessarily. And there are questions here.
Or with it.
Or with it, right? There, or even encouragement or participation. And it becomes a very difficult question to look into their different responsibilities, the different legal obligations that these non-state actors are subject to. We were mentioning, human rights obligations of tech companies. Many of those are voluntary. They're voluntary commitments that are being made, but they're not necessarily subject to the laws as we understand them when it comes to state responsibility and states' human rights obligations and states' obligations to then look into the conduct of persons located within their territory. And I think these raise a number of questions, not only as to the applicability of the rules to these individuals or groups, but states' obligations in managing, monitoring, and cooperating with that conduct, and how much of it can be attributable to
Varying degrees
states.
of involvement. Yeah, Gary has referred to this before as the democratization of armed conflict. Jonathan, could I turn to you for a first stab at the legal significance of this democratization that Lisandra has described so well for us?
No, I'm glad you brought up the issue. I mean, it's something of continuous concern for the ICRC. The pulling in of different portions of the civilian population, whether through organized groups, whether through individuals, or whether through the private technology sector, either they are, and I think you said it really well, either voluntarily or are encouraged to start doing things that put them in a position of supporting military activities of a belligerent to an armed conflict. And for the ICRC, we call it civilianization, but democratization, but that's the description of the phenomenon we're seeing. We also very much agree the scope and scale and transcending of international boundaries in terms of people's access to provide that support and technology company infrastructure to also be reliant upon by belligerents is something that I think puts real strains and tests and challenges on international law per se, but international humanitarian law as well. And for us, it's two or three different things. One is there's a considerable risk of a wide swath of the civilian population getting blurred into military operations that can produce a risk back on both those civilians who may not lose their protection, or civilian infrastructure that may not lose their protection, but in fact might be perceived as losing their protection. So this is one considerable risk.
Can I, right there, could I ask you to pull the legal thread a little bit more? I'm hearing DPH there, right? Direct participation in hostilities.
I would hear narrow application of DPH. I would hear presumption of civilian status where there's doubt. I would hear military objective and what the definition is for infrastructure that's being used by parties to an armed conflict. I have a feeling in many cases that is, and I think, Sean, when you wrote your piece on, at the time, CNAs, right? I think you flagged this issue.
You just dated me there. Thanks.
Yeah, sorry. Well, I think you dated yourself on your own piece. So I thought it was fair game. But I think you flagged for yourself this question of infrastructure, quote unquote, dual use infrastructure actually being where a lot of the pain will be produced in terms of questions around how militaries apply rules of international humanitarian law, distinction, proportionality, precaution. So these are things that the ICRC is focused on. And then I do want to also say there are also questions around, and it was already mentioned, but just to foot stomp it, do civilians know, because we are seeing it, that it is prohibited to direct digital activities and operations against other civilians?
Ooh.
Right? Do
that
governments
sounds
know?
broad. Are you saying that there's use for the DPH test beyond attack operations, or there's use for the military objective test even in a non-attack operation?
Well, DPH does not apply only to attack.
Well, I only
Even
become interested in DPH, do I not, if I want to intentionally attack the person in question, right? Or is there a different view?
I think I might be looking at the front end of the equation as opposed to the back end. So I'm looking at questions around And I actually think the question of compliance with IHL should not get conflated with questions around DPH. So the question of compliance with IHL is if there is a information operation that would qualify as an attack that a civilian is carrying out, there is a IHL compliance problem that we know civilians can be held accountable for war crimes. So do civilians, when they engage in these activities, know the rules of IHL? That's an important issue that needs to be unpacked and dealt with.
Okay. There is, I think, an interesting question if we step back. What is the panel's sense that in private-public partnerships, these participants that Lisandra described and that Jonathan has explained in a legal context to us really know what they're getting into? Do they really know the potential consequences of allowing their infrastructure to be used for military purposes, to participate in war, to support states' war efforts? We may open the door even here, Pete, to your neutrality points. We have just 5 minutes left. Can I start on this end of the table? What's your sense, Mamadou, about civilian awareness of the consequences of their participation or enlistment in information operations during armed conflict?
No, I think that you might need to distinguish two kinds of civilians. There are some that are closely integrated to military operations. Even if they keep their status as civilians, I think that they are more aware of the nature of their action. And I tend to think that these could be considered to a certain extent as really members of armed forces, even if they do not have this quality under the domestic law of the state that is employing them. But the others, the TikTokers, this I'm not sure that I could make a conclusion.
May not know what they're getting into. Jonathan, I know the ICRC now partners not only with armed forces, but also has extended its educational efforts to private industry as well. What's your sense of their awareness here of potential consequences of their involvement?
So my general sense is it's an uneven knowledge, and it is one that is improving over time. It is also my understanding that different parts of the private sector may understand these issues more than others. So for example, the commercial space sector seems to recognize this issue more quickly or already compared to other parts of the private digital sector.
And I suppose what matters when they become aware, let's address this part of the spectrum that has a high level of awareness. Is it changing their decisions about participation? Or are they full speed ahead? Let's make that money.
I don't know the answer to that.
Fair enough. Lisandra, do you?
I think this is another, it depends really. You look at Meta, for example, and this is outside the Imbello context, but their role in the Rohingya genocide is now acutely known to them. In the ICJ, for example, there was a parallel proceeding to try to compel Meta to divulge evidence to prove incitement to genocide and other forms of hate speech. And Meta's lawyers are deeply involved in that case within the United States courts. And so this company does have now acute knowledge of how its products, without its involvement at all, have been used to commit the kind of mass violence that we are worried about. And at least they seem to be, I can't speak for Meta, there seem to be some steps that are being taken. Whether this is enough, I don't know.
Sure.
But, and then, you know, of course you have Microsoft, right? I think they're acutely aware of the role of private sector technology. They're releasing reports left and right about nation state attacks and threats. But I think if you look at maybe individuals who are using this technology, I don't know if a lot of them know. Are they a group like Anonymous that maybe is involved in different conflicts and as a collective might have more knowledge, or are they a small group of college students who have no knowledge of this? It varies.
Pete, last word goes to you.
So I'll keep it short and sweet.
You have 1 minute.
I would say easy. I think there's a difference between those companies where you're able to obtain services outside of the traditional contracting and business mechanisms. Think, you know, social media type accounts where you get users, where I think you find much more risk and perhaps less understanding. I will tell you those companies where governments obtain services vis-a-vis like contract and business vehicles. As they become aware, they clearly are because prices are going up exponentially.
Fair enough. Good deduction. Sound. Well, please join me in thanking the panelists for their thoughts.